That tap on your taillight isn't random. It's not a habit. It's not a nervous tick. It's a setup. And if you don't know what to do the second it happens, you are handing the prosecution everything they need to convict you before the officer even reaches your window. I'm not exaggerating. I'm not trying to scare you. I'm telling you what defense attorneys know, what former cops have admitted on record, and what the Supreme Court has already confirmed in writing. Most drivers sit there completely unaware while evidence is being created on their vehicle in real time. They hand over their license. They answer every question. They say yes to the search. And then, 6 weeks later, they're sitting in a courtroom wondering how this happened. It happened because nobody told them what I'm about to tell you. Hit subscribe right now before we go any further, because this is the only place breaking down these exact legal counter moves in plain language that actually works on the side of the road, not just in a law school classroom. Here's exactly what you're going to learn today: why cops touch your taillight and what they're actually looking for when they do it. The exact words you say out loud the moment that tap happens. Why you should never roll your window all the way down and what to do instead. How to handle every question the officer throws at you without giving up a single right. What to say when they ask to search your vehicle. What to do if they call a K9 unit, and the post-top move that almost nobody does. The one that wins equipment violation cases in court before they even get started. And finally, a full step-by-step walkthrough of a real traffic stop using every single one of these tactics back to back. I've reviewed hundreds of traffic stop recordings. I've studied the case law. I've talked to people who walked away clean and people who didn't. And the difference between those two groups almost always comes down to one thing. The drivers who knew these moves used them. The drivers who didn't lost. Let's get into it. Here's what you've probably heard. Officers touch your taillight to leave their fingerprints on your car in case you flee the scene. That's the reason they'll put in a report. That's the reason that gets repeated in driver's ed and on forums online. That reason is real, but it is not the most important reason. The second reason and the third reason are what you need to understand. When a police academy instructor explains the taillight touch, they give two official justifications. First, leaving a latent thumbprint on the vehicle so that if you flee or the officer is incapacitated, investigators can link that specific car to the scene. Second, pressing down to make sure the trunk is latched. What officers call the jack-in-the-box scenario, where someone could be hiding in the trunk ready to ambush. On the surface, both of those sound reasonable, and both of those are real. But here is the legal reality that your local precinct will never tell you. That touch serves a third, far more aggressive purpose. By making physical contact with your vehicle, the officer is getting an up-close tactile look at the condition of your car. They are feeling whether that lens is cracked, loose, or damaged, and if that tail light is broken or gets broken in that moment, they now have a vehicle defect. That vehicle defect gives them reasonable suspicion to extend the stop beyond the original reason they pulled you over. It opens the door to more questions, more investigation, and in many cases, a full vehicle search. Think about what that means. You got pulled over for going 8 miles over the speed limit? That's a ticket? That's a fine. That should take 4 minutes. But if the officer touches your taillight and finds damage or claims to find damage, now they have a second reason to keep you there. Now they're asking where you're coming from. Now they're asking you to step out. Now the 4-minute stop turns into 40 minutes, and you're standing on the side of the road while they go through your car. All from one tap. Here's the part that makes this dangerous in court. If your taillight gets cracked during that touch and the officer claims it was already broken before the stop, you have no proof it wasn't. You didn't document anything. You didn't say anything on the record. You just sat there. So, in court, it becomes your word against their report. Judges believe reports, you lose. That's the setup. Now here's the countermove. The second you hear or see the officer make contact with your taillight, you do this. Pick up your phone, open your voice memo app or your camera, and say this out loud clearly so it gets recorded. It is, say the exact time. The officer has just made physical contact with my rear tail light. I am documenting that my vehicle equipment was fully functional and undamaged prior to this contact. Say the time. Say it clearly. Say it like you mean it. That's it. That's your first move. You are not being aggressive. You are not refusing anything. You are not breaking any law. You are creating a time-stamped record of the condition of your vehicle at the exact moment of contact. That record now exists. It has a timestamp. It has your voice stating clearly that the light was working before that officer touched it. If you have a passenger in the car, give them one job only. Their job is not to film the officer's face. Their job is to point the camera at the dashboard and the side mirrors. If they can capture the officer's hand making contact with your car reflected in the side mirror, you have just won what legal experts call the evidence war before the stop even progresses. If your case ever goes to court, your defense attorney now has evidence that you documented the taillight touch in real time. The prosecution can no longer claim that damage existed before the stop without directly contradicting your time-stamped recording. That is reasonable doubt. That is what gets cases dismissed. Here's the wrong way. You sit there quietly, you don't say anything. The officer touches the taillight. You don't react. They come to your window. You hand over your license. Everything feels fine. 3 weeks later in court, the officer's report says your taillight was cracked. That's why the stop was extended. You say it wasn't cracked. You have zero proof. The judge sides with the report. You lose. Here's the right way. The officer touches the tail light. You immediately pick up your phone. You say the line. You create the record. The officer hears you doing it. They know you're documenting. Now, they are extremely careful about what they claim happened to your vehicle, because there is a time-stamped audio record sitting on your phone that contradicts any false report. The legal backing for this is airtight. You have a First Amendment right to record police activity during a traffic stop as long as you are not physically interfering with the stop. Federal and state courts have confirmed this repeatedly. You are allowed to document what is happening to your vehicle. You are allowed to create evidence that protects you. Pennsylvania versus Mims said you have to exit the vehicle if ordered. It says nothing about your right to document what's being done to your property. Use that right every single time. Do you have a dash cam or do you use your phone to record during stops? Drop your answer in the comments right now because I want to know how many of you are already doing this. Now, the officer is walking from your rear bumper toward your driver's side window. And this is a moment most people completely waste. While they're walking, they are performing what's called a plain view sweep. They are scanning everything they can see through your windows. A stray pill on the floor, a pocket knife in the center console, anything that gives them a legal reason to go further. And the single biggest mistake you can make in the next 10 seconds is this: rolling your window all the way down. Most drivers do it automatically. It feels polite. It feels cooperative. But by rolling that window completely down, you are legally expanding the officer's access to your private space in a way most people don't realize. The plain view doctrine and the plain smell doctrine mean that if the officer's nose or eyes can access the inside of your car, everything they detect is fair game. If your window is wide open and a gust of wind carries a scent from your air freshener or from a nearby field, an officer can claim they smelled an intoxicating substance. In many states, that claimed smell alone is enough probable cause to search your entire vehicle without a warrant. Here's what you do instead. Roll your window down exactly 2 in, just enough to pass out your documents and hear their voice clearly. That 2 in gap creates a physical and legal barrier. It prevents the officer from leaning their nose or eyes into your private sphere. It makes it dramatically harder for them to justify a warrantless search based on smell or sight. If the officer says, "Roll your window down all the way," you have a decision to make. While they can cite officer safety to demand you lower it further, you should ask calmly and clearly, "Officer, for my safety and privacy, is it a legal requirement that the window be fully lowered, or can we conduct this stop through this gap?" This puts the burden on them to justify the request on the record. Whatever they say next, you have captured it. You are an informed driver, and they know it. Data shows consistently that drivers who demonstrate awareness of their rights early in a stop, who narrate, who document, who ask informed questions, have a significantly higher rate of being released with just a warning. Officers are not looking for a legal battle. They are looking for easy wins. When they realize you are an informed litigant, they understand that any creative reporting they do in their notepad will be challenged by digital evidence. You have just changed the dynamic of the stop before a single word about the violation has been exchanged. Now the officer is at your window. You've documented the tail light. You've held the two-in gap. You hand over your license and registration when asked. Good. That is the legal requirement. License, registration, proof of insurance. 3 things. Memorize that list, then it starts. Do you know why I pulled you over tonight? Where are you coming from? Where are you headed? Is there anyone else in the vehicle? Have you had anything to drink this evening? These questions sound like casual conversation. They are not casual conversation. Every answer you give is information. Information that can be used to extend the stop, build reasonable suspicion, and justify a search of your vehicle. Officers are trained in layered questioning techniques designed to lead you deeper into an investigation without you realizing it's happening. They are looking for conflicting statements. They are listening for hesitation. They are building a picture. And they are doing it while you think you're just being polite. Most drivers answer everything because they believe cooperating means talking. It doesn't. Cooperating means providing your documents. That is the legal requirement. That is all the legal requirement. Everything else, every question about where you've been, who you were with, what you were doing, that is optional, and you should decline every single time. Here is exactly what you say when the officer asks any investigative question, anything beyond asking for your documents. Officer, I'm not answering questions. Am I being detained or am I free to leave? Word for word, calm voice, no attitude, no explanation, no apology. Then you stop talking. This is critical. After you say that line, you go silent. You do not fill the silence with explanation. You do not say, I just don't feel comfortable or my lawyer told me not to talk. You say the line and you wait. The officer will most likely say, you are being detained for the traffic violation. That is legal. That is fine. Now, you say this. I understand. I will not be answering any further questions without my attorney present. That's it. You've now invoked your Fifth Amendment right. The stop cannot legally extend based on your answers anymore. They write the ticket or the warning. The stop ends. Let me show you the contrast clearly. Bad way. Officer asks where you're coming from. You say you were just at a friend's house across town. They ask which friend. You say a name. They ask what you were doing. You say just hanging out. They ask if anyone was drinking. You say not really. Now the officer has a reason to smell your breath, ask you to step out and call it a sobriety check. You answered your way into a 40-minute roadside investigation from a simple speeding ticket. Good way. Officer asks where you're coming from. You say, I'm not answering questions. Am I being detained or am I free to leave? Officer says you're being detained for the lane violation. You say, I understand. I'm not answering questions without my attorney present. Officer writes the ticket. Stop ends in 4 minutes. The case law here is rock solid. Miranda Veers, Arizona established your right to remain silent. It applies before arrest too. You do not have to be in handcuffs to invoke the right to stay quiet. And in Salinas versus Texas, the Supreme Court reinforced the importance of explicitly invoking this right out loud, which is exactly what these lines do. Courts have confirmed this in traffic stop context repeatedly. You only have to provide 3 things: license, registration, proof of insurance. Everything else is a gift you're handing the prosecution for free. Stop giving gifts. Still with me? Good, because this next tactic is the one that protects you when everything else fails. At some point during the stop, the officer might say one of these things. Do you mind if I take a quick look in your vehicle? Can I just check the back seat real fast? You wouldn't mind if I searched your car, would you? Here is the single most important thing I can tell you about that moment. If the officer had legal grounds to search your vehicle, they would not be asking for your permission. Read that again. The request for consent exists because they do not have probable cause. They are asking because they need you to voluntarily give up your Fourth Amendment rights. And the overwhelming majority of drivers do exactly that because they're nervous. They want to seem cooperative, and they think saying no makes them look guilty. It doesn't make you look guilty. It makes you legally protected. Here's exactly what you say. I do not consent to any searches. That's the line. 5 words. Say it clearly. Say it once. Do not add anything to it. Do not say, I don't have anything to hide. But the word but erases everything before it and sounds like you're negotiating. You are not negotiating. You are invoking a constitutional right. Do not explain. Do not justify. Just say the line. Here's why this matters. Even if they search anyway, if you consent and they find something, it is admissible in court. Full stop. You handed them permission. The evidence stands. If you refuse consent and they search anyway, your attorney immediately files a motion to suppress. The prosecution must now prove the search was legally justified. If they can't, and often they can't, the evidence gets thrown out. No evidence, no case, case dismissed. Your refusal to consent does not just protect you in the moment. It protects you in court weeks later, even if the officer ignores your refusal and searches anyway. United States v. Drayton confirmed that police can ask for consent, but also confirmed that you have every right to refuse and that your refusal cannot be used as evidence of guilt. Florida v. Boston backed this up, saying no to a search is protected. It cannot by itself create reasonable suspicion. You are covered. Use it. Now, let's talk about what happens when they push back. You've said, I do not consent to any searches. Some officers will say, if you've got nothing to hide, why won't you let me search? This is a psychological pressure tactic. It is designed to make you feel like invoking your rights is suspicious behavior. It is not. It is constitutional behavior, and you know that. Now here's what you say. Officer, I am exercising my constitutional rights. I do not consent. You repeat your position. You do not argue. You do not ask them to explain themselves. You restate your rights once clearly, and then you go silent. Some officers will then say they are going to call a K-9 unit, and this is where 90% of drivers fold. They think if I say no to the dog, I look guilty. If the dog alerts on something, even if I have nothing, I'm in trouble. I might as well just let them look. Do not fold. This is exactly where the Supreme Court of the United States has given you one of the most powerful legal weapons available to any driver on any road in America. In 2015, the Supreme Court ruled on Rodriguez v. United States. The decision was crystal clear. Police cannot extend a traffic stop to conduct a K-9 sniff without independent reasonable suspicion. Here's what that means in plain language. A traffic stop has a mission. That mission is to address the specific traffic violation you were pulled over for. Once the officer has checked your license, run your plates, and written the ticket or warning, the mission is over. The stop must end. If the officer finishes the ticket but then says you have to wait 10 more minutes for the drug dog to arrive, they are officially violating your Fourth Amendment rights. Unless they have independent evidence of another crime, they cannot legally hold you just to wait for a dog. When the officer mentions a K-9, do not argue and do not get angry. Simply check your phone and say this out loud clearly for your recording device. Officer, has the mission of this traffic stop completed? Am I being detained further? And if so, what is the specific legal justification for extending this stop beyond the time needed to complete the citation? By using the words mission of the stop and extending the stop, you are speaking the exact language from the Rodriguez decision. You are signaling to that officer and to their body camera that you know the rule. You are creating a record that if they make you wait, any alert that dog gives will be challenged in court because the detention itself was unconstitutional. There is one more thing you need to understand about K-9 units specifically. Many people think, I don't have drugs, so the dog won't alert. That belief is dangerously wrong. Kennys are trained to please their handlers. If a handler subconsciously or consciously signals the dog will alert. This is what legal experts call a false positive. It happens more often than most people realize. If the dog arrives and alerts and the officer begins searching your vehicle, do not resist physically. Do not move, but narrate immediately into your recording device. The officer is searching my vehicle despite my explicit refusal of consent. I am asserting that the canine alert was a pretext and that the duration of this stop has exceeded the legal limit established in Rodriguez 5, United States. That narration is your courtroom defense being built in real time. If they find anything, even something completely unrelated to what they were looking for, your attorney will file a motion to suppress. If the judge sees that the officer held you for 15 minutes waiting for a dog after the ticket was already written, the judge will throw out everything found in that search. The entire case dies right there before it ever gets started. Most people stopped reading a long time ago. If you're still here, you already understand why this matters more than almost anything else you'll learn about protecting yourself during a traffic stop. Drop a comment right now that says, "I know my rights, so I can see who's actually paying attention and ready to use this." Now, I want to show you the move that almost nobody does, the one that wins equipment violation cases before they even get to a courtroom. It happens after the stop ends. The officer hands you your ticket or your warning. They say you're free to go. Most people peel out of there as fast as possible. Don't. Before you put the car in drive, do one final piece of documentation. Say into your recorder clearly, "The stop concluded at," and say the time. "I am now leaving." During the stop, I documented the initial taillight contact. I invoked my Fifth Amendment rights and I refused all searches. Then pull over at the nearest gas station or well-lit parking area. Get out of your car. Take out your phone. Film your taillight. Hold the camera close enough that the condition of the lens is clearly visible. State the time again on the recording. Show clearly that the light is functional. Show that it is not cracked. If the officer claimed your taillight was broken as the justification for the stop or for extending it, you now have time-stamped video proof showing the exact condition of that light within minutes of the stop ending. That is how you win equipment violation cases. That is how you get points removed from your license. That is how you take what looked like a simple ticket and turn it into a case that gets dismissed at the first hearing. Now, let's run the complete playbook from start to finish so you can see exactly how all of these moves connect in a real stop. You're driving home, it's late, you see lights in your mirror, you pull over safely, turn off the engine, turn on your interior light and place both hands on the steering wheel where the officer can see them. You do not reach for your glove box yet. The officer approaches your vehicle from behind. You hear the tap on your tail light. Immediately, within seconds, you pick up your phone, open your voice recorder, and say out loud, "It is 11:22 p.m. The officer has just made physical contact with my rear tail light. I am documenting that my vehicle equipment was fully functional and undamaged prior to this contact." The officer begins walking toward your window. You roll it down exactly 2 in. They arrive at your window. They ask for your license and registration. You pass your documents through the 2 in gap calmly and without drama. They ask, "Do you know why I pulled you over tonight?" You respond, "I'm not answering questions. Am I being detained or am I free to leave?" The officer says, "You're being detained for a lane violation." You say, "I understand. I'm not answering any questions without my attorney present." They ask where you're coming from. You say, "Nothing." They ask again. You repeat, "I'm not answering questions." The officer walks back to their vehicle. They run your plates and license. They come back with a warning in hand. They hand it to you and then say, "Before you go, do you mind if I just take a quick look in your car?" You look at them calmly and say, "I do not consent to any searches." They say, "Why not? You got something in there?" You say, "Officer, I'm exercising my constitutional rights. I do not consent." They say they're going to call a canine unit. You check your phone and say clearly, "Officer, has the mission of this traffic stop completed? Am I being detained further? And if so, what is the specific legal justification for extending this stop beyond the time needed to complete the citation?" Silence. They look at you. You look forward. You do not speak again. "All right. Have a good night." You wait until they leave. You say into your recorder, Stop concluded at 11:31 p.m. I documented the taillight contact, invoked my rights, and refused all searches. You drive to the nearest gas station, you film your taillight, you go home. No arrest, no illegal search, no court date you didn't prepare for. And if they do try to take you to court on the equipment violation, you have time-stamped video of your taillight shot within minutes of the stop. You win. Now, compare that to the driver who doesn't know any of this. They sit silently while the tail light gets touched. They roll their window all the way down before the officer even arrives. They answer every question: where they're coming from, who they were with, what they were doing. They say, "Sure." When the officer asks to search, the officer finds an open container in the back seat from 2 weeks ago that was completely forgotten. Now it's a charge. Now it's court. Now it's a fine, a record, and insurance rates that climb for 3 years. All because they didn't know a handful of lines to say out loud. The legal framework tying all of this together pulls from cases the Supreme Court has already settled. Terry v. Ohio established that officers need reasonable suspicion to detain you and probable cause to search. Pennsylvania v. Mims confirmed you must exit if ordered, but doesn't strip you of your other rights. Schneckloth v. Monte ruled that consent searches are valid only when consent is truly voluntary, meaning consent given under pressure or confusion may not hold up. Miranda v. Arizona locked in your right to remain silent before any arrest. Rodriguez v. United States drew a hard line around how long a traffic stop can legally last. These cases protect you, but only if you actually invoke what they guarantee. So, here is your complete playbook condensed into 5 moves. The second the officer touches your taillight, record yourself stating what happened, the exact time it happened, and that your vehicle was fully functional before the contact. When the officer approaches, roll your window down to in, not all the way. When the officer asks investigative questions, say, "I'm not answering questions. Am I being detained or am I free to leave?" And follow up with, "I'm not answering any questions without my attorney present." If they ask to search, say, "I do not consent to any searches," once clearly with no added explanations. If they push back or threaten a K-9, say, "Officer, I'm exercising my constitutional rights. I do not consent." Calm, clear, and then silent. And after the stop ends, film your taillight at the nearest gas station with a timestamp to close the door on any equipment violation claim. That's the entire playbook. 5 moves. Memorize them like your freedom depends on it. Because in certain situations, it does. Cops are doing their job. They are trained to investigate. They are trained to get consent. They are trained to ask questions designed to make you give up your rights without realizing what you're handing over. None of that is illegal. It's just how the system is built. But the system also built in legal countermoves, and you just learned every single one of them. The drivers who know these tactics walk away. The drivers who don't end up fighting charges they never should have faced in the first place. Next week, I'm covering the marijuana smell claim. The moment an officer says, "I smell marijuana," and what that legally means, what they can and can't do next, and the exact response that has gotten cases thrown out at the suppression hearing stage. There's also a massive legal shift happening in over 30 states right now that has made the "I smell weed" excuse almost unusable for police in those jurisdictions. If you don't know the specific phrase to say when a cop claims they smell something, you're leaving yourself wide open to a total vehicle teardown. Subscribe right now, or you're going to miss it. Smash the like button if this just changed how you think about traffic stops. Share this with someone you know who drives because you might be saving them from a conviction they never saw coming. Drop a comment telling me which tactic you had absolutely no idea about before today. And if you're ready to use this, drop "I know my rights" below right now. Stay calm. Know your rights.